School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 2 Business Forms and Legislations. Unit 4 The Companies Act 2013 Part 3.
Share and loan capital. A public company raises the necessary funds by issuing shares, debentures, and by accepting public deposits. Let's discuss them in detail. Share capital. Share capital is the capital raised by the company by issue of shares. It is the corpus or fund to be used for the object of the company to generate profits. The Memorandum of Company provides for share capital clause. Companies limited by guarantee or unlimited companies need not have share capital. Various terms used with reference to share capital can be understood as: Number 1. Nominal or authorized or registered capital. This represents the maximum share capital which the company is authorized to issue by its memorandum and upon which it pays the stamp duty. This form of capital has been defined in Section 2, Clause 8. Number 2. Issued capital. It denotes the nominal value of that part of authorized share capital which is issued or offered to the general public from time to time for subscription and includes the shares allotted for consideration other than cash. This form of capital has been defined in Section 2, Clause 50. Number 3. Subscribed capital. It is that part of the issued share capital which the general public for the time being has subscribed or application has been received from the public. This form of capital has been defined in Section 2, Clause 86. Number 4. Called up capital. It denotes that part of allotted or subscribed share capital which has been called up by the company from the subscribers to pay. This is as per Section 2, Clause 15. Number 5. Paid up capital. It is the total amount paid or credited as paid up on shares issued. It is equal to called up capital less calls in arrears. Number 6. Uncalled capital. It is the remainder of the issued capital which is not been called. It may be called any time but is subjected to the term of issue of shares and provision in Articles of Association. Number 7. Reserve share capital. A limited company by a special resolution may declare that a portion or whole of its uncalled share capital shall not be called except in the event of company's winding up, and this portion of uncalled share capital is called reserve capital. Types of shares. The capital of the company is divided into invisible units of a fixed amount. Each of such unit is called a share. Share means a share in the share capital of a company and includes stock, except where a distinction between stock and share is expressed or implied. Evidenced by share certificate as per Section 2, Clause 84, it is a measure of the interest in the company's assets to which a person holding a share is entitled. The rights and obligations attached to a share are those prescribed by the memorandum and the articles of a company. A shareholder not only has contractual rights against the company but also certain other rights which accrue to him according to the provisions of the Companies Act. Stock can be defined as the aggregate of fully paid up shares consolidated and divided for the convenience of holding into different parts. Its advantage is that, unlike the share which is indivisible, it may split into a fraction of any amount without regard to the original face value of share. Stock can be validly issued only when shares are fully paid up. According to the provisions under Section 43, the share capital of a company limited by shares shall be of two kinds, namely, number 1, equity share capital with voting rights or with differential rights as to dividend, voting or otherwise in accordance with prescribed rules. All share capital which is not preference share capital means equity share capital. Number 2, preference share capital. It is that part of the issued share capital of the company limited by shares which carries or would carry a preferential right with respect to payment of dividend and repayment of capital in the case of a winding up. Issue of shares. A company can issue its share either at par, at a premium, or even at a discount. Number 1, issue of shares at par. Shares are issued at par when subscribers are required to pay only the amount equivalent to the nominal or face value of the shares issued. Par value is the notional face value of the shares which a company issues to its investors. Number 2, issue of shares at a premium. If the buyer is required to pay more than the face value of the share, then the share is said to be issued at a premium. The premium cannot be treated as profit and therefore cannot be distributed as dividend. The amount of premium received in cash and the equivalent of it received in kind must be kept in a separate bank account known as the securities premium account. And number 3, issue of shares at a discount. If the buyer of shares is required to pay less than the face value of the share, then the share is said to be issued or sold at a discount. Share can be issued at a discount if it is authorized by a resolution. That is, number 1, the issue is of class of shares already issued. Number 2, the maximum rate of discount must not exceed 10%. Number 3, not less than 1 year has, at the date of issue, elapsed since the date on which the company was entitled to commence business. Number 4, issued within 2 months of the sanction by the Company Law Board. Number 5, every prospectus must mention particulars of the discount allowed on the issue of shares. Next is issue of sweat equity shares. Sweat equity shares means equity shares issued by the company to employees or directors at a discount or for consideration other than cash. Sweat equity shares may be issued for providing know-how or making available intellectual property rights, say patents or value additions. And last is rights issue as per Section 62, Clause 1A. The existing members of the company have a right to be offered shares when the company wants to increase its subscribed capital. Such shares are known as right shares. Or when a company, whether private limited company or a public limited company, listed or unlisted company, offers its shares to the existing shareholders in proportion to their existing shareholding in the company for the purpose of raising fresh capital for the company. All of it refers to the rights issue. In other words, it is a preemptive right that an existing shareholder has in a company in preference to the outsider. It is a non-dilutive pro rata way to raise capital. It is not mandatory to buy the rights offered. A shareholder can either ignore their rights and let it lapse or transfer or sell the rights to other interested investors. With these rights, the shareholders of the company can purchase new shares at a discounted rate to the market price. Legal requirements. Number 1. The offer shall be made by notice specifying the number of shares offered and limiting a time not being less than 15 days and not exceeding 30 days from the date of the offer within which the offer, if not accepted, shall be deemed to have been declined. Number 2. unless the articles of the company otherwise provide. The offer aforesaid shall be deemed to include a right exercisable by the person concerned to renounce the shares offered to him or any of them in favor of any other person, and the notice referred to in clause I shall contain a statement of this right. And number 3, after the expiry of the time specified in the notice aforesaid, or on receipt of earlier intimation from the person to whom such notice is given that he declines to accept the shares offered, the board of directors may dispose of them in such a manner which is not disadvantageous to the shareholders and the company. Number 6. Bonus issue. Bonus shares refers to a further issue of shares made by a company having share capital to its existing shareholders without any additional cost in proportion to their existing holdings. Bonus shares are fully paid up shares issued to its members out of its free reserves or the securities premium account or the capital redemption reserve account. No issue of bonus shares shall be made by capitalizing reserves created by the revaluation of assets. Legal requirements. The bonus shares can be issued only when number 1. It is authorized by its articles. If not, then amend the AOA or Articles of Association. Number 2. Recommended by the board and authorized in the general meeting of the company. Number 3. The company has not defaulted in payment of interest or principal in respect of fixed deposits or debt securities issued by it and payment of statutory dues of the employees such as contribution to provident fund, gratuity and bonus. Number 4. The partly paid up shares, if any outstanding on the date of allotment, are made fully paid up. Number 5. The company which has once announced the decision of its board recommending a bonus issue shall not subsequently withdraw the same. Number 6. The authorized capital should be sufficient to issue bonus shares. If not, it should be increased first. Number 7. Bonus issue must be made out of free reserves, built out of the genuine profits or securities premium or capital redemption reserve account. Number 8. Reserves created by revaluation of assets should not be used for issue of bonus shares. Number 9. Bonus issue should not be made in lieu of dividend. And number 10. Other such conditions as may be prescribed. Transfer and transmission. Transfer. It refers to the transfer of title to shares voluntarily by one party to another for adequate consideration under contract. Transfer deed is executed in transfer of share and stamp duty is payable on the market value of shares. Liabilities of transferor cease on the completion of transfer. Transmission. It refers to the transfer of title to shares by the operation of law, that is death, insolvency or lunacy. It is initiated by legal heir or receiver. On death of a shareholder, his shares are transmitted to his legal representative. When a shareholder becomes insolvent, his shares are transmitted to his official receiver. And on shareholder becoming lunatic, his shares are transmitted to his administrator appointed by the court. Provisions relating to transfer and transmissions are stated in section 56. Buyback of shares. A company, whether public or private, is empowered to purchase its own shares or other securities in certain cases out of these sources. These sources are number 1, its free reserves, or number 2, the securities premium account, or number 3, the proceeds of any shares or other specified securities. However, buyback of any kind of shares or securities shall not be made out of the proceeds of an earlier issue of the same kind of shares or same kind of other specified securities. Conditions for buyback. Number 1. The buyback must be authorized by the article. Number 2. It should be approved by Board of Directors at a board meeting and or by a special resolution, that is SR, passed by shareholders in general meeting depending on the quantum of buyback. That is, approval of Board of Directors up to 10% of the total paid up equity capital and free reserves of the company, and approval of shareholders up to 25% of the aggregate of paid up capital and free reserves of the company. Number 3. Shares to be bought back must be fully paid up. Number 4. The buyback of shares of private and unlisted public companies may be from the existing shareholders on a proportionate basis and by purchasing the securities issued to employees of the company pursuant to a scheme of stock option or sweat equity. Number 5. Before the buyback of shares, the company shall file with the Registrar of Companies a letter of offer. Number 6. The offer for buyback shall remain open for a minimum period of 15 days, but not more than 30 days from the date of dispatch of letter of offer. Number 7. Buyback shall be completed within a period of 1 year from the date of passing of special resolution or board resolution as the case may be. And number 8. The ratio of the aggregate of secured and unsecured debts owed by the company after buyback shall not be more than twice the paid up capital and its free reserves. Surrender and forfeiture of shares. Surrender of shares. It implies giving the shares back to the company either by way of settlement of a dispute or for any other reason. The Companies Act contains no provision for surrender of shares. Thus, surrender of shares is valid only when Articles of Association provides for the same and where forfeiture of such shares is justified or when shares are surrendered in exchange for new shares of same nominal value. Forfeiture of shares. If a shareholder fails the call on share, the company has certain options. These are: number 1, to sue him for the amount due, and number 2, forfeit the shares, that is, take away the shares forcefully. A company may, if expressly authorizes by its articles, forfeit shares for non-payment of calls, and the same will not require confirmation of the tribunal. Where power is given in the articles, it must be exercised strictly in accordance with the regulations regarding notice, procedure, and manner stated therein. Otherwise, the forfeiture will be void. The power of forfeiture must be exercised bona fide and in the interest of the company. When the shares have been forfeited, the defaulting shareholder ceases to be a member of the company and he loses all rights or interests in his shares. Surrender is effected with the assent of the shareholder, whereas forfeiture is a proceeding in invitem, that is, against a reluctant shareholder. But a surrender of shares not fully paid can only be accepted where forfeiture would be justified. Debentures. The debenture is the most common form of raising loan from the public by a company. Under Section 2, Clause 30, debenture includes debenture stock, bonds, or any other instrument of a company evidencing a debt, whether constituting a charge on the assets of the company or not. When debentures are issued, the applicants are given certificates under its common seal, if any, or under the signatures of 2 directors or a director and the company secretary if he has been appointed, representing the money they have lent to the company. Main characteristics of debenture are: number 1, a debenture is in the form of a certificate. Number 2, a debenture certificate must be delivered within 6 months from the date of allotment of debentures unless the company is prohibited by any provision of law or any order of court, tribunal, or any other authority. Number 3. The company pays periodic interest on the amount raised by issuing debentures till they are fully redeemed. Number 4. Generally, debentures carry a charge that is fixed or floating on the company's assets. However, debentures may be issued without charge. Number 5. Like shares, debenture too is a movable property which is transferable as per the provisions contained in the articles. Number 6. Debentures may be redeemed at the end of full term or in installments, say yearly or bi-yearly, or any other period like in 2 installments. And number 7. Debenture holders have no right to vote at any meeting. Deposits. Apart from shares and debentures, public deposits are yet another important source of raising fund by a company. According to the Section 2, Clause 31 of the Act, read with Rule 2(1)(c) of Companies Acceptance of Deposits Rules 2014, deposit includes any receipt of money by way of deposit or loan or in any other form by a company. There are various receipts by the company that neither are nor include in deposits. These are: Number 1. Receipts from the central government or a state government or a local authority, or any amount received from any other source whose repayment is guaranteed by central, state, or local government, or any amount received from a statutory authority constituted under an Act of Parliament or a state legislature. Number 2. Receipts from foreign governments, foreign or international banks, multilateral financial institutions, etc. Number 3. Receipts as a loan from any banking company or from State Bank of India or its subsidiaries or from a cooperative bank. Number 4. Any amount received as a loan or financial assistance from public financial institutions notified by the central government or any regional financial institutions, insurance companies, or scheduled banks. Number 5. Any amount received by a company from any other company. Number 6. Any amount received by way of subscription in respect of a chit under the Chit Fund Act 1982. Number 7. Any amount brought in by the promoters of the company by way of unsecured loan in pursuance of the stipulation of any lending financial institution or a bank. And number 8. Any amount received in the course of or for the purposes of the business of the company.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.